We have discussed Articles 21 to 23. Now, we will tackle Articles 24 to 29 on the same topic of penalties. What are not considered as penalties in Article 24? Measures of prevention or safety not considered as penalties. Number 1, the arrest and temporary detention of accused persons as well as their detention by reason of insanity or imbecility or illness requiring their confinement in a hospital. Another is the commitment of a minor to a youth detention home or facility. Third, suspension from public office during the trial or in order to institute proceedings. Fourth, administrative fines and other corrective measures which superior officials may impose upon their subordinates. Fifth, deprivation of rights and reparations which the civil laws may establish in penal form. They are not considered penalties because they are not imposed as a result of judicial proceedings, meaning those mentioned in numbers 1, 3, and 4 are merely preventive measures before the conviction of the offender. However, under Article 29, the period of preventive imprisonment will be deducted from the term of imprisonment if the accused is eventually convicted. Now, here are the rules. First rule, the deduction is full if the detention prisoner had agreed voluntarily in writing with the assistance of counsel to abide by the same disciplinary rules imposed upon convicted prisoners. Otherwise, the deduction will only be 4/5 or 80% if the detention prisoner did not agree in writing to abide by the said disciplinary rules. So here, when a person is detained, he has a choice as to what rules or disciplinary rules are to govern him. He can choose to be governed by the rules imposed upon convicted prisoners, or he can choose to be governed by the rules imposed upon mere detention prisoners. So, in such a case, if he chooses in writing with the assistance of counsel to abide by the same disciplinary rules imposed upon convicted prisoners, in the event of his conviction and service of the sentence imposed on him, his period of preventive detention will be credited in his favor in full. Otherwise, it will only be 80%. But the period of preventive imprisonment will not be credited if the detention prisoner is, letter A, a recidivist or has been previously convicted twice or more times of any crime, or letter B, when upon being summoned for the execution of his sentence, he has failed to surrender voluntarily. Now, I have previously discussed with you what recidivism is or who a recidivist is. So I will no longer touch on this topic for purposes of this discussion. I will go to giving you an example of letter B. Let us say X was charged and arrested for the crime of homicide. And from the time of the filing of the case up to the time when he decided to post bail, he has been preventively imprisoned for 2 years. Now, a year after, while he was out on bail, a judgment of conviction was promulgated against him. So much so that he must now, if he does not wish to file an appeal or appeal his case to the next higher court, or he fails to avail of the remedies granted him to stay or suspend the execution of his sentence, he must surrender voluntarily to the authorities so that he can start to serve his sentence. If he fails to surrender voluntarily to the authorities, then his period of preventive imprisonment will no longer be credited in his favor. Now, if the accused has undergone preventive imprisonment for a period equal to the possible maximum imprisonment of the offense charged to which he may be sentenced, he shall be immediately released without prejudice to the continuation of trial. I had a case once where the accused, I was the prosecutor, and the accused had been preventively detained for a number of years, and such number of years equaled the possible maximum imprisonment of the offense charged. His counsel, the defense counsel, moved and requested the court to order his release, and the court accordingly granted such request. But even with the release of the accused, the trial still continued, and eventually the accused was convicted. Now, in case of conviction, will he still serve the penalty imposed on him? No more. Why? Because the accused, in such a case, has already served the possible maximum imprisonment of the offense charged. Now, if the crime committed is punishable only by destierro, the most that the offender may be held under preventive imprisonment is 30 days, whether the proceedings are terminated or not. Let us hold our discussion of what destierro is when we reach that portion. Just absorb the information that if the crime committed by the accused is only punishable by destierro, like, for example, the concubine in the crime of concubinage, the concubine who is arrested, charged and arrested for the crime of concubinage, shall only be preventively detained for up to 30 days. After 30 days, he or she should be released, whether the proceedings are terminated or not. Because in the event of conviction, he will not be imprisoned, but he will be banished to a certain place, because that is the nature of destierro. The fines mentioned in number 4 of Article 29 are imposed by administrative agencies, not by the court, because if it is the court that imposes a fine, then it is already penal in nature. An example of deprivation of rights in penal form is Article 332 of the Civil Code. It is called in penal form because the provision is a civil law provision, but the aspect of deprivation of rights seems to be in penal form in the case of parents who are deprived of parental authority if they are found guilty of the crime of corruption of minors. Now, let's go to the 3 scales of penalties in the revised penal code. I have endeavored to discuss this because there seems to be a confusion as to what scale of penalty is to be used for certain situations. So let us examine what are these scales and their respective purposes. Article 25, take note, is the scale to be used when distinguishing between principal and accessory penalties. And the principal penalties are further subdivided into capital, afflictive, correctional, and light penalties. Okay? On the other hand, Article 70 is the scale to be used when there are two or more sentences to be served by the convict in the order of their severity. This happens when a convict is to serve multiple sentences. And this also discusses the threefold rule. Now, you will notice that in Article 70, the penalty of destierro is placed under arresto menor. This is so because arresto menor is more severe as it involves a complete or total deprivation of liberty. Okay. In arresto menor, the convict is imprisoned, put in jail as a rule. Whereas in destierro, the convict will not be imprisoned, but the convict will just be banished to a certain place. Article 71 is the scale to be used when graduating penalties for the purpose of applying Article 61 in relation to Articles 50 to 57. Now, note that in Article 71, the penalty of destierro is this time placed above arresto menor. Why is this? This is because destierro, being a correctional penalty as classified in Article 25, is higher than arresto menor, which is only considered a light penalty. So, you will now notice the difference between Article 70 and 71. Article 70 talks about severity of the penalty. So, yes, arresto menor is more severe because it involves complete deprivation of liberty. Whereas destierro is not. Destierro is only banishment. On the other hand, Article 71 talks about whether a penalty is afflictive, correctional, and light in accordance with Article 25. And under Article 25, since destierro is classified as a correctional penalty, then it has to be placed higher than arresto menor, which is only considered as a light penalty. What are principal and accessory penalties? Principal penalties are those stated in Article 25 under the heading Principal Penalties. They are the penalties imposed for specific felonies in Book 2 of the Revised Penal Code and hence must be expressly imposed by the court in the judgment of conviction. Upon the other hand, accessory penalties are those stated in Article 25. Under the heading Accessory Penalties, they follow the principal penalties imposed for the crime as a matter of course. Hence, they need not be expressly stated in the judgment. Are there penalties that are both principal and accessory? The answer is yes. Perpetual or temporary absolute disqualification is one. Perpetual or temporary special disqualification is another, and also suspension. These penalties are found in both classes of penalties under Article 25. For example, Article 236, which punishes the crime of anticipation of duties of a public office, provides for suspension as a principal penalty. Articles 226, 227, and 228, which punish the crime of infidelity in the custody of documents, provide for temporary special disqualification also as a principal penalty. Considering that death as a principal penalty is provided for in Article 25, Does that mean that the courts can impose death for certain crimes? The answer is not anymore. Why? Because RA 9346, which was approved on June 24, 2006, prohibited the imposition of death penalty. The law, RA 9346, expressly repealed RA 8177, the law that provided for death by lethal injection, and it also repealed RA 7659 with respect to the imposition of the death penalty law, and all other statutory provisions requiring the application of the death penalty. When did Republic Act 9346 take effect? While the law states that it shall take effect immediately upon its publication, it should be given retroactive effect because it is favorable to the offender. The same shall also retroactively apply even to an offender who is a habitual delinquent, because the intent of the law is to eliminate the death penalty without qualification. This, in effect, is an exception to Article 22, which prohibits retroactivity if the person to be benefited is a habitual delinquent. Now, what are the provisions in the RPC that have become inoperative because of RA 9346? There are a lot, no? But these are the more important ones that have become inoperative. Article 25 on capital punishment. Article 47 on the instances where the death penalty shall not be imposed. Article 63, paragraph 2 on the rules for the application of indivisible penalties. Article 71 on the inclusion of the death penalty in the order of severity. And Article 74 with respect to the penalty higher than reclusion perpetua. What is the effect of RA 9346 to laws that impose the death penalty? The effect is that the penalty shall be downgraded to reclusion perpetua when the law violated makes the use of the nomenclature of the penalties of the revised penal code. Now, the penalty shall be downgraded to life imprisonment when the law violated does not make use of the nomenclature of the penalties of the revised penal code. Note that prior to RA 9346, the death penalty was imposable under two frames of reference under the revised penal code. Number one, it was imposed as a maximum penalty in reclusion perpetua to death. And number two, it was also imposed as a single penalty itself. Now, under these two frames of reference, the penalty will now just be reclusion perpetua pursuant to RA 9346. Now, how do we distinguish reclusion perpetua from life imprisonment? Okay. This is an important distinction because from experience, even a lot of lawyers until now cannot distinguish between reclusion perpetua and life imprisonment. So, to clear the air, here are now the distinctions. For reclusion perpetua, it is a penalty imposed for serious offenses in the RPC. It also has a fixed duration, 20 years and 1 day to 40 years. And it is accompanied with accessory penalties like civil interdiction or perpetual absolute disqualification. So take note of the important aspects of reclusion perpetua. Now, in comparison with life imprisonment is a penalty imposed for violations of certain special penal laws. Although, you will notice later on that there are special laws or special penal laws that use the nomenclature of the penalties imposed in the RPC. But in general, life imprisonment is a penalty imposed for violation of special laws. You can never see life imprisonment as a penalty in the revised penal code. In addition, and as compared with reclusion perpetua, life imprisonment has no fixed duration. Okay? And life imprisonment does not carry with it accessory penalties, whereas reclusion perpetua, if the court sentences an accused to reclusion perpetua, it carries with it accessory penalties, okay, as stated in Article 25. There is no penalty of life imprisonment in the RPC, as what I have already pointed out. Now, for felonies under the RPC, courts are enjoined to use the nomenclature of penalties in Article 25. It is because the system of penalties under the RPC is different from the system of penalties under special penal laws. However, for both reclusion perpetua and life imprisonment, the maximum duration of a convict's sentence shall only be 40 years. Okay? Do not think that a convict can be imprisoned for life. There is no such thing as imprisonment for life, for that would violate the threefold rule in Article 70. Okay, when we reach Article 70, we will discuss the threefold rule. Also, for both reclusion perpetua and life imprisonment, a convict becomes eligible for pardon by the President after 30 years. Okay, you might be confused, no, because reclusion perpetua and life imprisonment are both considered pena perpetua, meaning to say, after 30 years imprisonment, a convict becomes eligible for pardon by the President. It doesn't mean that the President should pardon them, but they become candidates for pardon. Their names will be submitted to the President, and the President may exercise his pardoning power. But take note that a President may at any time, after a judgment of conviction, pardon the offender. He doesn't have to wait for 30 years. When fines are to be considered afflictive, correctional, or light. This is found in Article 26 as amended by RA 10951. A fine is considered afflictive if it exceeds 1.2 million pesos. Correctional if it does not exceed 1.2 million pesos but is not less than 40,000 pesos. Light if it be less than 40,000 pesos. Note that in imposing fines, the court can fix any amount within the limits established by law, and in fixing such amount, it must consider the presence of mitigating or aggravating circumstances and the wealth or means of the offender. Now, what are the corresponding accessory penalties for reclusion perpetua, temporal, prision mayor, prision correccional, arresto mayor, or arresto menor? They are found in Articles 41 to 44. For reclusion perpetua and temporal, they carry with them the accessory penalties of civil interdiction for life or during the period of the sentence, and perpetual absolute disqualification. For the principal penalty of prision mayor, it carries with it the accessory penalty of temporary absolute disqualification, perpetual special disqualification from the right of suffrage. For prison correctional, it carries with it suspension from public office or suspension from the right to follow a profession or calling, or perpetual special disqualification from the right of suffrage if the duration of the said imprisonment exceeds 18 months. And for arresto mayor and arresto menor, these principal penalties carry with them the accessory penalty of suspension of the right to hold office and the right of suffrage during the term of the sentence. The accessory penalty common to all the principal penalties is the accessory penalty of confiscation or forfeiture of the instruments or proceeds of the crime. Okay, take note of that. Now, there is no crime in the RPC which carries the principal penalty of bond to keep the peace. You remember that in Article 25, there is such a penalty as bond to keep the peace. In such a case, this penalty is inoperative. Nowhere can you find in any of the penalties, or rather in any of the felonies in Book 2, that carries or imposes the principal penalty of bond to keep the peace. Now, there is this principal penalty of bond for good behavior, which is not found in Article 25 but is prescribed as a penalty under Article 284 for the crime of grave or light threats. Do not interchange this with bond to keep the peace in Article 25. In bond for good behavior, the person making the threats may be required to post bail as a security that he will not molest the person threatened. Otherwise, the person making the threats will be sentenced to destierro. Now, as to, or you may ask why this penalty of bond for good behavior is not stated in any of the scales of penalties in the RPC is a question that should be answered by Congress. Okay? Maybe they just forgot to place this penalty among the penalties provided for in the 3 scales. Now, what is the duration of the penalties under the RPC? Reclusion perpetua, 20 years and 1 day to 40 years. Take note, it has a duration, although it is considered an indivisible penalty. Reclusion temporal, 12 years and 1 day to 20 years. Prision mayor and temporary disqualification, if imposed as a principal penalty, has a duration of 6 years and 1 day to 12 years. Prison correccional, destierro, and suspension, if imposed as a principal penalty, has a duration of 6 months and 1 day to 6 years. Arresto mayor has a duration of 1 month and 1 day to 6 months. Arresto menor has a duration of 1 day to 30 days. And bond to keep the peace, there is no duration or specific duration stated. The court may impose such period of time as the court may determine. But again, I will reiterate, this penalty, bond to keep the peace, is virtually inoperative. Originally, reclusion perpetua had no fixed duration prior to its amendment by RA 7659. It was intended to last for the rest of the convict's natural life, although under Article 70, the maximum duration of imprisonment shall only be 40 years. RA 7659 later amended Article 27 and fixed its duration from 20 years and 1 day to 40 years. Be that as it may, reclusion perpetua is still an indivisible penalty even if it has a fixed duration. RA 7659 did not intend to make it a divisible penalty. It is the only indivisible penalty left after the death penalty was abolished by RA 9346. Okay, let's now go to the definition and nature of the penalty of destierro. What is destierro in Article 87? The duration of destierro is 6 months and 1 day to 6 years. It is considered a principal penalty if you notice, if you have already noticed, in Article 25. Destierro is a punishment whereby a convict is banished to a certain place and is prohibited from entering the place designated in the sentence, which should not be less than 25 kilometers but not more than 250 kilometers. If the convict enters the prohibited place, he thereby commits the crime of evasion of service of sentence under Article 157. So take note of that. Now, even if the range of destierro is 6 months and 1 day to 6 years, it is still considered lighter than arresto mayor. I have already pointed this out. Because the latter, arresto mayor, means complete deprivation of liberty, while destierro is only banishment or prohibition to enter or reside within a radius of 25 kilometers from the place designated in the sentence. Now, destierro as a principal penalty is imposed in the following situations. Number 1, it is imposed as a penalty with respect to a legally married person who catches his or her spouse in the act of sexual intercourse with another, and while in that act or immediately thereafter, he would kill or inflict serious physical injuries upon his or her spouse or the mistress or paramour or both of them. So, let us say, for example, the spouse in flagrante delicto catches in the act his other spouse having or engaging in sexual intercourse with another person, and out of rage, out of anger, he kills or inflicts serious physical injuries upon either or both of them. He will still be charged for the crime of parricide, but the court will not impose upon him a sentence of imprisonment, but only destierro or banishment. Destierro is also imposed in the crime of grave or light threats, as when the offender is required to put up a bond for good behavior but failed or refused to do so. Okay? So, a penalty of destierro will be imposed upon him. The reason there is the offender hopefully would not be able to carry out his threat. Another instance where destierro is imposed is in the crime of concubinage. This is the penalty to be imposed for the concubine under Article 334 of the Revised Penal Code. Destierro is also imposed when the penalty is only arresto mayor, but the offended party is entitled to a privileged mitigating circumstance which lowers the penalty by 1 degree. So, if you notice in Article 71, again, I have already emphasized this, the penalty under arresto mayor in Article 71 is destierro, not arresto menor. Destierro in this instance is higher than arresto menor, but lower than arresto mayor. For purposes of computing the penalty, when does it start? The answer to this is found in Article 28 of the Revised Penal Code. when the convict is already under detention because of his preventive imprisonment, as when he did not post bail or was not able to post bail during the pendency of his criminal case, the computation, take note, will start from the day on which he commences to serve sentence. But the convict in such instance is entitled to a deduction of full time or 4/5 of his preventive imprisonment. This was what I've already emphasized in Article 29, if you remember. With respect, however, to temporary penalties like disqualification and suspension, the answer is it depends. If the accused or convict is already under detention, then it starts from the day on which the conviction becomes final. Why? Because even if the accused had been under detention or is already under detention, that period of detention cannot be used as the reckoning point of when he is to serve the penalty of disqualification and suspension. If the convict is not under detention, then it starts from the day on which the convict commences to serve sentence. If the convict is not yet in prison and the penalty consists in deprivation of liberty, then it starts from the day that the convict is placed at the disposal of the authorities for the enforcement of the penalty. The reason why the computation of temporary penalties starts only from the day the conviction becomes final is because under Article 24, the preventive imprisonment of an accused is not considered a penalty. The period of preventive imprisonment and good conduct time allowance will be deducted from the term of imprisonment. This is so provided in Article 29 in relation to Article 97 as amended by Republic Act 10592. So here, let us first know the purpose of preventive imprisonment. It is to prevent the accused from escaping or going into hiding. But the accused can, however, post bail if the crime is bailable. If the crime is not bailable, like murder or rape, as the case may be, and the evidence of guilt is strong, the accused should be detained. He should be denied bail. As already discussed, the period of preventive imprisonment will be deducted from the term of imprisonment if the accused is eventually convicted. The deduction is full if the detention prisoner had agreed voluntarily in writing with the assistance of counsel to abide by the same disciplinary rules imposed upon convicted prisoners. I am just reiterating this. Otherwise, the deduction will only be 4/5 credit or 80% if the detention prisoner did not agree in writing with the assistance of counsel to abide by the said disciplinary rules. The convict will be entitled to immediate release if the period of his preventive imprisonment plus good conduct time allowance or GCTA will equal or surpass the maximum period of his sentence. Again, this is just a reiteration of what I have already pointed out. But the benefit of this provision, I'm referring to the credit of his preventive imprisonment and his availment of good conduct time allowance. These two benefits will not extend to recidivists, to those summoned for execution of sentence who failed to surrender voluntarily. These also do not extend to habitual delinquents, escapees, and persons charged with heinous crimes like rape, murder, violation of the dangerous drugs law, especially referring to the sale of dangerous drugs. Convicts who are imposed the penalty of reclusion perpetua and or life imprisonment may be credited with the period of their preventive imprisonment and GCTA or good conduct time allowance, provided they are not recidivists, etc., as already mentioned above. In such a case, the credit for preventive imprisonment shall be deducted from 30 years because in cases involving pena or in penalties involving pena perpetua, the standard number of years is 30 years, and this includes life imprisonment. And in case the principal penalty that the convict has to suffer is destierro, he shall be released after 30 days of preventive imprisonment. So, destierro is also a principal penalty, and what makes it different from imprisonment is that imprisonment involves total deprivation of liberty, whereas destierro involves only partial deprivation of liberty in the sense that the convict who is sentenced to a penalty of destierro is deprived of his liberty to travel to a certain place within a certain radius designated in the sentence or in the judgment. And in such a case, if the person or the accused who is charged with a crime punishable by destierro will be arrested and detained, the law provides that he can only be detained for up to 30 days, and after 30 days, he should be released whether or not the proceedings are terminated. Yes, the case may continue, the criminal case may continue, but he will already be released. He need not be detained. So that ends our discussion on the first part of penalties, and I will provide in another video the discussion on the second part of penalties. So the second part will involve Articles 30 to 88 of the Revised Penal Code. Thank you.